If a spouse hides or dissipates assets and I find out about it, it's going to be a real problem, because the fact of the matter is the courts hate this. It's theft. It's actually a criminal offense. The fact of the matter is hiding or dissipating assets is something that is treated very, very seriously in Florida. They can be subject to sanctions. They might even be subject to incarceration, depending on what they did. The best thing to do if you're worried about a spouse dissipating assets is to get those assets protected by a court order. Put them in escrow and make sure no one can mess with it until the judge properly distributes it. Well, commingled assets in Florida is pretty much equitable distribution. It's pretty much marital assets, right? A person's paycheck goes into a joint account. That's the obvious explanation of a commingled asset. But even money that's acquired just from regular working, or a 401k that's acquired or accumulates during the course of a marriage, is considered a commingled asset. Most assets, whether you're trying to or not, inside of a marriage are commingled by the mere nature of the fact that they were acquired during the course of the marriage. Each asset's different though, and if there was something that was completely separate, like an inheritance or something like that, or intended to be separate from the marriage, that might be considered non-marital property, but it needs to be taken on a case-by-case basis. Unlike spousal support, the length of the marriage doesn't play that big of a role in asset distribution. What does play a big role is what assets were actually acquired at what point in time. So the date of the marriage is basically a line in the sand. And everything before that really should be a separate asset. It's not a marital asset because it wasn't acquired during the course of the marriage. But everything that was acquired during the course of the marriage, generally speaking, is subject to equitable distribution. Now, there could be arguments on both sides about that issue, but it's not about the length of the marriage. It's about what was acquired during that marriage itself, even if it was a relatively short time. Sometimes people want to know about a modification of asset division, but really it comes down to this. When the divorce case is finalized, the judge is going to be looking at the equitable distribution, the tables that the attorneys prepared, and determining what is fair, what is equitable when it comes to dividing assets and liabilities, debts, right? So to modify that later is kind of a strange thing because it would have already been done during the marriage itself. It's not like time sharing or child support, which is an ongoing issue. Asset distribution really should be done at the time the final judgment's entered. When one spouse experiences a significant change in income, sometimes we get the question of how does that affect asset division? But income itself is totally separate from marital assets. Assets are things or money, but not ongoing income. What happens is this. If income changes significantly, spousal support might be subject to be changed in the future, and child support is definitely subject to be changed in the future, but not necessarily the marital assets that were acquired during the course of that marriage, because that's set in a fixed moment in time.